Welcome everyone to this wonderful seminar event, Teaching International Criminal Law Approaches in Asia and Europe, an event that's co-convened by the European Society of International Law and the Asian Society of International Law interest groups on international criminal justice. So the aim of today's event essentially is to share best practices, share struggles, surface biases. If all knowledge is situated, then really just to share our situated experiences of teaching international criminal justice in different geographies around the world. We've spotlighted a few themes that we'd like to cover. We don't have to cover all of them, but just to kind of inspire us in our discussion. So how do we orient our courses on international criminal law? Do you focus on particular events or case studies, for example? Do you localize your teaching in any way? What methods do you engage with in your teaching of international criminal law? Is it dialogical? Is it moot courts? Is it clinical education? What theories do you engage with? Do you engage with Twale scholarship, feminist scholarship, queer approaches, for example? What challenges in general do you face when teaching international criminal law, whether it be in terms of resources or substantive content? And have you reflected on decolonizing the curriculum with respect to your international criminal law courses? Do you engage with questions of positionality, whether of yourself, of your authors or your students? Do you consider geographic and epistemic diversity? So there's a lot of different perspectives that we could bring to this question. But to help guide us on our way, we have two wonderful speakers to start off this conversation. And we do want this conversation to be, fairly informal, fairly relaxed. So I will introduce the first speaker, which is Dr. Christine Schwebel-Patel, who is an associate professor and reader at Warwick University. And currently an Alexander von Humboldt Fellow at the Humboldt University in Berlin, which I understand will be followed by a Leverhulme Research Fellowship next year. Dr. Schwebel taught at the University of Liverpool, the University of Leiden, and King's College London, and initiated a research network in 2012 dedicated to critical approaches to international criminal law. Interestingly, for today's purposes, in 2009, Christine was awarded with the King's Excellence in Teaching Prize, so is well placed, I believe, to offer thoughts and reflections on pedagogical practices, and has written recently very interesting papers on decolonizing the curriculum and given talks on decolonizing the curriculum more generally. So it's my pleasure to welcome Christine with us today. And I'll now hand over to my colleague Wu Ling to introduce the second speaker.
So, thank you so much to everyone for taking the time to attend on a weekday. So thank you to my ESIL organizers, Barry and Michelle, and to my ESIL organizers, Romel and Mike. And I want to most of all thank all the participants. It was really a great experience for me reaching out and connecting with fellow educators. So I think that one of the main purposes, I was really excited about this workshop when we started talking about this idea, because I think that teaching, even though many of us may be teaching ICL, International Criminal Law, for a long time, most of us may be the only one or two colleagues in our institutions teaching this course. And the course is very popular among students, even though it's not as popular as arbitration or commercial law, but it's very relevant and important today with the situation of Ukraine in Europe and the situation of Myanmar in Asia. And I think community exchange is really important in academia, though our daily working lives aren't really structured for this. I benefited greatly from the help of mentors and my peers, and I really hope that this can be the start of connections and networks that can help us teach and research more effectively in the future as teachers, as educators, and as researchers. So we hear very often that the future of international criminal law is domestic. And I think that moving forward, possibly the teaching of international criminal law will be more comparative. So there'll be a need for more cooperation and collaboration. So to be very honest, I am very ashamed to admit this, but I have very little knowledge of the domestic laws on core international crimes and universal jurisdiction, in Asian countries, their neighbors to Singapore. And I really hope that having these connections and conversations can really help us move collaboration and cooperation forward. So without further ado, I will be introducing our speaker from Vietnam. She's Associate Professor Wan. She's the Vice Director of the Center for Legal Research on Human and Citizens' Rights and the Vice Dean of the Criminal Law Faculty, both at the Ho Chi Minh City University of Law, where she lectures and researches on criminology, criminal law, and international criminal law. So Associate Professor Wan will start off, and then I believe we will follow with Christine's very short presentations. And we've asked the speakers to keep it short because we hope that we can spend most of our time with discussion. So thank you. Over to you, Professor Wan.
Thank you. So hi everyone, it is very nice for me to be connected with the ICL community. So let me will be very brief on ICL teaching in Vietnam. Okay. So regarding ICL teaching in Vietnam, I would like to focus on an overview of this teaching, and secondly, particular ICL teaching at my university, Ho Chi Minh City University of Law. So first, now ICL was delivered at the 2 levels at the Bachelor of Law. So we have recently, about 15 years recently, there's a sharp increase in the universities which provide for LLB programs in Vietnam. Previously, there were only about 4 or 5 universities and awarded LLB, but nowadays there are around 100 universities can deliver award LLB. However, we see that among these 100 universities, there is only 1 university in Hanoi, that is in the north of Vietnam, have ICL as an optional subject for LLB, whereas we have criminal law as a must for LLB in Vietnam. So therefore, this picture can show that ICL teaching is very underdeveloped here in Vietnam. Regarding the Master of Law, LLM, here we have it as a compulsory subject for LLM, which is specialized in criminal law and criminal procedure law. And at our university, there is only me to deliver this subject. So actually, looking at this picture, I'm very sad of the ICL community here. So regarding ICL teaching at Ho Chi Minh City University of Law for master degree, it is 2 credits. And the orientation, I focus mostly on history of ICL, some characteristic and relationships between ICL and the national criminal law, and also some sources for studying or doing research on this subject. And I use a lot of Russian materials for my teaching because I did have my bachelor degree in the former Soviet Union. So therefore, this subject was officially delivered there for a very long time, and it was developed very systematically. And according to those materials I read, the ICL not only focus on international crimes, such as crimes, genocide or war crimes or against humanity, but also transnational crimes. So therefore, here I also deliver some knowledge on UN conventions against certain types of transnational character, for example, UNCOC, UN conventions on organized transnational crimes, as well as UN drug control conventions. So regarding the contextualize the topics, so I think that Vietnam has suffered wars, so many young people nowadays, they have a lot of knowledge of war crimes. So therefore, it's really very easy for me to introduce this subject. And another problem here is transnational crimes, and this is an increasing serious crimes. So therefore, it's really not a problem for me to contextualize that. The methods used in my teaching, so I use seminars and also small group discussions and dialogue teaching. So we do not have any moot parts or any kind of case study, but mostly I would like the students to compare the regulations of Vietnam and the UN conventions in order to find out ways to improve the national legal system. Challenges in teaching this subject actually is a resource, because here most of resource materials are written in English and especially in Russian. So therefore, I just collect several articles, journal articles relating to some aspect of these subjects for them. And I do have one book relating to this, but focus on human rights protections and international rights. Another challenge, I suppose, is also the substantive knowledge of this subject. Even me myself just know some good knowledge at some aspects, but not all. So that is, I think it's a challenge. And another questions provided whether it is overlap with other subjects. So I find that there's no such an overlap. And student demand, because as LLM, this is a compulsory subject, so therefore no problem at all. Decolonizing, it is not reflected in my teaching. So therefore it's just a very brief introductions about the ICL teaching in Vietnam. So let me stop sharing, okay?
Thank you so much, Professor Huan. Barry, do you want to introduce Christine?
Yeah, so Christine, please take the floor. You have the floor.
Thanks so much. I'm going to attempt to share my screen as well, which I was very impressed just now how easily. I still have troubles with this. Okay, let's see. It's not. Okay, that doesn't look like the usual. Okay, because otherwise I'm seeing a strange screen here. What I might do is, Barry, if I can send it to you via email, would you be able to share it then at your end?
Yeah, give it a go.
Okay, I'm just going to try and do that because I do have a little excerpt. Usually my slides are not very exciting, but this time I do have a little excerpt from a MOOC course. Okay, that's all right. That's not working either because actually the little film that I have is saying it's too big.
Well, I just want to take this opportunity to welcome the other people who just entered the room. Thank you so much for making the time to attend this event. So I noticed there are a couple of new participants that entered.
All right, I'm not able to share my screen at the moment, so I will. I'll just talk without the screen. So the first thing that I wanted to say, after thanking you, of course, for the invitation to be able to speak to you about teaching, and of course the irony that right now I'm on a fellowship, which means that I'm not teaching at present. is that I wanted to say that teaching actually is really a collaborative endeavor. We often see it, I think, as very personal to us, but I really think that my teaching has been collaborative, not only in the people who I've spoken to about teaching, and Michelle is here, and Michelle and I have written together about teaching, but also teaching projects that I've had with others. I tell you a little bit more about a mooting project that I'm engaged with with Walter Werner. And then at the University of Warwick, where I usually teach international criminal law, we have a teaching team, and the syllabus that we have is very much informed by all of our contributions to that. So let me say a little bit about the syllabus that we have at Warwick, and if my slides were working, this would be, I did want to share that with you, because often seeing other people's syllabi is sort of the most interesting thing about talking about teaching. So what we do in international criminal law is that we teach it in an in-context way, and led by our research interests. So we have a whole week dedicated to international criminal law and political economy, because that's been my research interest. We have a whole week dedicated to international criminal law and gender, because Solange Mathan, who co-teaches on the module writes on that. And I think that sort of research-led teaching, there are lots of benefits to that. Now, I can't take credit for what is the really innovative way of doing assessments in international criminal law at Warwick, because that was conceptualized by my colleagues who taught the course before me. So what the students do is they have a weekly reflective journal where they write about a short reflection on, well, it can be on the reading, it can be on the teaching, like the seminar, something that stood out for them, or it can be something related, something that inspired them to go and look at, watch a film, for example, on international criminal law. So every week they write a reflection, and then at the end, these reflections get put together and are submitted as an essay, which we then mark in an essay form. So that's part of the assessment. The other part of the assessment is a conference. So the students are organized into panels and present conference papers like you would have at an academic conference. They get about 10 minutes. They get to choose their own topic, and we have a session, a workshop where we discuss topics and draft beforehand. And then it's expected that at the conference, the students also participate in the audience as well as on the panels. So I think in terms of assessment, that's a really great form of assessment. Now, to the what kind of topics and what it's inspired by. So the literature is certainly inspired by 12 research, feminist and decolonial research. If I were to redesign the course, I think I would rather than calling it international criminal law, at this stage, I would probably call it something like global criminality, to reflect, I think, also what Wei-Ling said in that there's comparative elements which are really important, domestic elements, transnational elements. So I think I would, at this stage, if I were designing this from scratch, I would feel quite limited in calling it international criminal law only. And that's also, Barry and I had a conversation about this last week, and he said, and I thought that was quite fitting actually. International criminal law is not that powerful anymore, or at present, certainly. And I think seeing where the centers of power are would be more interesting in a module that were conceptualized a little bit broader. Right, let me see. Then teaching materials. Now we use the standard cases, of course, and journal articles, but also films, podcasts. I was going to give a shout out to the asymmetrical haircuts. Women who do a fantastic job of and they have really a great repository of materials now of quite a few years of podcasts, which are fantastic. We use musical compositions and we use poetry, so it's really broad in terms of the teaching materials that we use. I'm happy to talk a little bit more about that. One of the assumptions that we come to international criminal law with is not that it's a discipline that can solve problems of international crime, but rather that it is a neo-colonial, patriarchal and capitalist endeavor. So I think starting off with the assumptions about the discipline that you're teaching is really important, and being open about that. That's not to say that if there are students there that are really dedicated to a liberal view, a liberal internationalist view of international criminal law, and not awarded a space. They definitely are, and really interesting discussions are come about through that. Right, so, and then my remaining minute or so, I wanted to just talk about experimental mooting. In international criminal law and in international law, I'm sure you know about the mooting competitions in international law. The most famous one is, of course, the Jessup moot, but you will have heard of ICC moots and so on. Now, from when I first started teaching international criminal law in 2012, I had what I called a radical mooting element to it, where I imagined the students to, I asked the students to imagine that they were in the courtroom and prepare something disruptive for the courtroom. And an invitation to bring the political into the courtroom. And through many years of talking to people and now collaborating with Walter Werner, this has turned into a project on experimental mooting, where we have just last week, actually, we met in Amsterdam at the VU there, and there were teams from Rwanda, Zimbabwe, Indonesia, China, the UK, and the Netherlands, and Suriname, and I might be forgetting some, but anyway, there were 6 teams in total. The teams are mixed, so they don't stay in their national groups, and they were given the Coney case to discuss. So we invited them to present and prepare opening statements, and then we had a simulation of a press conference, and the students were invited to bring into the courtroom aspects of the colonial past of Uganda, of the ICC as focusing disproportionately on Africans and the stereotyping that happens there, and so on. And what happens through this experimental moot is really interesting. Again, very happy to take lots of questions, but it was really interesting for us to see what about the courtroom. And essentially everything in the courtroom in a moot is a prop, but they weren't really used as props, right? It was still very much adherence to a regular kind of courtroom, but then the arguments that came in through some support and an encouragement were really quite radical and creative. So yeah, I think I'll leave it there. Very happy to take any questions, and I'll see in the meantime whether I can somehow choose share my slides, because there's one particular clip that I wanted to share, which is from the mooting. I'm saying competition, it's not a competition, it's a mooting event from last week. That was really great. But thank you for inviting me to be part of this discussion. And apologies, I've got a sick child at home. My daughter is coughing in the background.
Thank you so much. Thank you to Christine. Thank you to both of our speakers for those really brilliant opening remarks to get us on our way. I'm just going to pick out a few themes and then really open it up to questions, thoughts, reflections, reactions. So if you do want to take the floor, please just, I guess, use the raise hand feature. There should be one. Otherwise, just physically raise your hand and hopefully we'll see you. But yeah, there's so many interesting cross-cutting themes there. I think the one that I picked out was what does it mean? What is international criminal law today when we teach it, right? Because when I was a student, international criminal law was very clearly demarcated as, you've got the core crimes, we're going to focus on the core crimes. We've got the tribunals that try the core crimes of war crimes, genocide, crimes against humanity and aggression. The ICC, this new thing, it's going to be big. We're going to focus on that as well. And really everything else was, not really touched upon too much. Things like transnational criminal law were really kind of relegated to the sidelines. Any kind of comparative criminal law was not mentioned at all, I don't think. Maybe very briefly if it was a particular doctrine like joint criminal enterprise, but even then it was really through the vantage point of an international space, like an international court. But both of our speakers mentioned, transnational criminal law becoming a prominent part of their teaching. Also this idea of global criminality, which Christine mentioned. So I think one of the questions would be interesting to reflect upon further is, what is international criminal law today as a subject to be taught? Where are the emphases there? Another theme is theories, right? What different theories do we rely on in our teaching? And are there any challenges that we experience when applying and relying on different theories? Is there a danger of overloading students with too many perspectives? Do you find that, or is it fine? Is it okay? Do the students kind of thrive on the pluralism of perspectives that you can bring to the classroom? And then we also heard a variety of methods used in the classroom, including some creative methods like experimental mooting, reflective journals, and the more kind of traditional kind of small group discussions. And I guess it's also interesting to hear what you find effective in practice. What kind of things have you tried out in the classroom that you find effective? And are any of these choices rooted in the context in which you teach, both in terms of what is international criminal law, what theories you rely on, and what methods you look at?
I think Jordan wants to say something. I think Jordan has hand up.
Perfect. Yeah, perfect. Please.
Okay, thank you very much, Barry. So how to pronounce Chia, Dr. Chia?
Yeah, you just can call me Chia, it's fine.
Okay, right. Okay, so thank you very much. This is the experience from Indonesia. Actually, this is very unique, since when we just talk about the topics and method, I think we already have the same perspective and view of what we are doing in front of the class and also in front of the students. But I have the very unique challenges, and I think it has also happened to what Dr. Hua said about overlap in the materials between criminal law and also international criminal law itself. So we got the same problem, but specifically in my campus, Universitas Muhammadiyah Yogyakarta, and I think even in Indonesia, I understand what is wrong when many professors distinguish between criminal law, which focuses on domestic criminal issues only, and they also separate with the international law itself. And as a result, international criminal law is more a subset of criminal law with a local focus than international criminal law itself with an international focus. It also happened because syllabi are often done together. I mean, like team teaching, I often see that the approach is only very national criminal law with international component only and nothing more. For example, like the teacher just discussed about terrorism, but it is they got the wrong definitions on transnational crime. So they said terrorism is a part of international law, but they still use the national legal system, no more than that. And then another thing is because they got different definition on what is transnational and also what is international law itself. So transnational and international. So sometimes I have to switch some topics to be international, and of course humanitarian law and also international criminal law would be a part of my explanations. But of course I have to also make what is the another topic to be very short when I have to follow all the flow that all professors agreed in the early of the meetings in front of the students. Thank you.
Thank you so much. Should we turn to Mark Lamberg?
Thank you. First, I want to thank the organizers of this event. I mean, there were several questions here, and I would like to address one of the questions: what is international criminal law? And I mean, we may teach under different circumstances, but for us, we have almost all of our students are non-Swedish students, and they come many from Europe, but also from Southeast Asia and People's Republic of China. And what we've done for many years is to focus on the ICC, the UN ad hoc tribunals. But research-wise, I've come to the conclusion that more and more is happening on the domestic level. So that has brought about kind of a redefinition what I mean with international criminal law and how I think about the course, to more discuss kind of domestic examples of prosecution. And I think we can all to an extent do that. I mean, Sweden is one example that I'm using, but I'm also trying to use the students because when I have lectures or seminars, I always ask the students how if they have similar problems or how they solve a particular legal problem in their country. And I also have writing assignments where I encourage the students to write about how is it regulated in their countries, do they have any interesting cases, and that kind of brings about at least two good things. One good thing is to kind of make it more domestic, the first one, and the other one is also kind of adapted to various experiences and sets of skills. So I think, and this may be a little bit kind of frightening or challenging because we all kind of, or many of us have learned one way of doing ICL. This is a different way of doing it. But I think maybe it's a little bit more difficult, but I think in the end it can give more back. Thank you.
So just to pick up on the themes touched on by our speakers and the participants who intervened. And I think that I thought it's really interesting, and because this also came up when I was speaking to the different participants from Asia, that ICL in quite a few countries is not taught as an elective, as Professor Wan also pointed out. There's only one university doing really that in Vietnam, and I was wondering, is it because, and Christine already mentioned that very often, increasingly, you see ICL is quite irrelevant given how things are, the power dynamics, how things are evolving in today's landscape. And I was wondering whether there are ways of reframing the ICL as a subject that makes it more relevant. And I was wondering whether our participants could share about why perhaps their institution does not see ICL as relevant. And I'm sorry to be like, I'm not targeting or arrowing anyone here, but I was wondering whether he told me you could share your experience in your own university, because we actually talked about this on email.
Thank you very much for inviting me, professors. In Japan, maybe Professor Mizushima also knows this situation as well. Not so many universities provide the courses of international criminal law and just domestic criminal law. So I have to give lecture of just one lecture of international criminal law during my international law in general part, so only once a year. So I can only briefly touch on the history of international criminal law and especially Tokyo Tribunal history, because in Japan, not so many people take this experience as favorable. So, and I touch on ICC and the recent development of ICL, and I cannot touch on transboundary issues or transnational crimes. So in Japan, this is the case. I think only a few universities give a lecture of international criminal law. Thank you.
Thanks so much, Itomi. I don't know whether, just to share very frankly, I tried to bring in transnational crime into my course this year, and I had planned it for the second part of the course, and I just was overwhelmed with trying to teach the first part properly. And then, so the other problem I had was I don't want to overwhelm students with material, because even you give them a lot, but nothing may be going in. So I think that thinking about what to take out of the expected ICL syllabus is also a huge problem. And I was wondering whether anyone has things to share about that, because I would really appreciate the feedback. Yeah. Leticia?
Yes, thank you, and hi everyone. I see very familiar faces here, so it's a pleasure to engage in this conversation with you all. I think, William, you are touching upon one of the challenges that to which I also related in relation to the speakers' presentations, and that's the challenge of balancing what is expecting from a student that accomplishes a course in international criminal law. So what is the knowledge that is expected from that student, and what we want to add to that knowledge as teachers. And I think this has to do with the learning objectives. So what we expect students to learn from our particular course. For instance, a special way of engaging with the material we provide. For instance, a critical engagement with case law, for instance. But I think the first part, and this is also how I also teach international criminal law at Leiden, in particular, Leiden University College, is really oriented towards striking this balance between a doctrinal knowledge and a critical approach to international criminal law. So I think it's important to reflect on how we do things. And of course, we all come with bias. My own bias is that I have been educated according to, I think, a vision of international law that was Antonio Cassese's vision. And I think this is probably or reflects a positive approach to international criminal law. But then, of course, throughout our journey as academic, we come to realize the limits of this vision. So new visions are shaped along the journey. So I think in my own experience, we need to be, in a way, faithful to the discipline, but also cynical in a way. And this is, yeah, just echoes Marty Koskaniami's famous piece between faith and cynicism. Thank you.
Great, thanks so much, Letitia. Shall we go to Michael next, please?
Thank you, Barry. So the reverse, I think, is it's interesting because from the Philippines, and we don't really have an elective on international criminal law, but we teach it as a special topic or in seminars when the issue is burning, particularly in the Philippines. And so the reverse is the situation here. And it's interesting because while the teacher talks about being limited by teaching the doctrinal, here the interest really comes from the investigation that the state is involved in. And the challenge is get to the doctrinal because much of the interest revolves around whether liability exists and whether there are enforcement issues with respect to the Philippines, and then they lose interest when we get to the more doctrinal areas of ICL. So I just want to present that situation as well, which poses a challenge also in terms of separating, delineating the area of ICL, at least here, from the international rights law, where it's always tied. The discussion is always tied to that, and distinguishing the two fields and where intersections lie, that is the challenge. And it also really goes into formulating the syllabus here as well, and what the students expect when they enlist in a class called International Criminal Law and expect human rights instruments, for example, to be discussed there. So just a different situation, but still a problem of the question of whether there would still be demand if this matter at the ICC is going to go away, and whether it will sustain attention on the part of students. Because again, I echo the point that without this investigation, I can say that it would still largely be about domestic criminal law that's going to be the focus, and therefore you have a challenge of teaching when it becomes really international and what values try to protect there.
Thank you. That's so interesting. And before I hand the floor to Gregory, just to say, I think this theme about student expectation is something that we can maybe pick up on further, right? To what extent should we be fulfilling a student demand? And to what extent should we be kind of not necessarily ignoring that demand, but challenging expectations of students in ways that they might not have anticipated? So I just think that's an interesting thing. So, but Gregory, please.
Thanks, Barry, and thanks for having me, and great to see everybody here. I just wanted to throw in another, I guess, angle to this, which is, focusing on the audience. So we offer it as an elective, and I've taught it to undergraduates, and I think that makes a difference. So if I'm teaching to undergraduates, I'm going to probably take a bit of a different approach from if I'm teaching it to graduate students. And I'm trying to take into account where the students are coming from, and I guess trying to present the materials in a way that I think will be engaging and that will be digestible. So one of the questions that has come up is, for example, do you try to include transnational criminal law? And I think I would probably shy away from that in at least our context here, because I think that would probably be putting too much into it, trying to shoehorn too much into it. We talked about actually creating, and in fact, I've engaged in some of planning in this regard, a separate transnational criminal law class, where we look at things like terrorism and trafficking and things like that. But with the international criminal law class, there's already so much that we're trying to shoehorn in. So obviously, apart from the core crimes and the history of international criminal law, personally, I'm also trying to inject the local perspective, and because we're in Asia, trying to look at what local justice might be like, and getting the students to appreciate the fact that there are alternative justice methods, whether it be truth commissions or other kinds of local rituals and things like that. So that necessarily, limits the time. The other thing is talking about victims and the whole, if you will, transitional justice aspect of it, but at the same time, due process rights for defendants. So I try to put some criminal procedure in there. And when you add that all up, that's a lot for one semester. So I think just in terms of trying to understand and remember who the audience is, looking at the scope, and then trying to inject other viewpoints and remembering that, we're in Asia. When you put that all together, it's a fairly big challenge. I just want to add too that one thing that helps is I try to use film as much as possible. So whether it's showing, say, a clip from War Don Don or a clip from the Nuremberg trials or whatever it is, or Hotel Rwanda or whatever, I try to do that and then use different teaching techniques, including things like team-based learning. For example, I've had them teach genocide to each other, and I've just said, look, I'm going to be in the background. I'll give you some guidance as I can, but I assign different groups to teach different parts of it, and I found that's been very effective. They interact, they learn how to teach and self-assess amongst themselves. So, I think there are a lot of layers that you can look at when it comes to this in terms of trying to be successful in the classroom. And I really appreciate that you guys have opened this up for all of us to discuss and share our ideas, because I think it's super helpful to hear other perspectives. And, I hope, whatever I've said might be somewhat helpful. But again, thanks, guys. Appreciate it.
Thanks so much, Gregory. That's really interesting. Let's turn to Marina.
Hello, everyone. Pleasure to be here. Apologies if I don't make sense. I have COVID, so COVID brain, but I really want to intervene. And yeah, just picking up on Gregory's point, graduates, undergraduates, where I teach, we teach both undergraduates and graduates, and I teach comparative criminal law. This is the methodology of IE Law School in Madrid. So we teach everything comparative. And international criminal law is actually a mandatory part of comparative criminal law class. So it's mandatory and it's part of bachelor's curriculum. And then I have another course which is for graduates. So what resonated a lot with me was the relevance of moot court. I used to use moot court for undergraduates, and I would take ICC moot court. There is ICC moot court every year. I would take a puzzle, I would adjust it a little bit, make it a bit easier, and have a proper moot court for many years. But I lost interest in that during COVID, primarily because I just don't feel that the competitive angle is that relevant. It could be also changing in my own thinking. So when I saw Christine's post on EGIL Talk, I think a couple of months ago, about this experimental moot court, it really resonated, because I just don't get passionate anymore to have students compete against each other and try to win. I'm more like, hi, how can we find a solution? Can we focus on solution orientation? And I noticed that students resonate with this approach too. So I still have some sort of moot court, but I actually invite them to work in groups, and they prepare a brief together, trying to find a solution to a particular problem. And then they present it to me in a session as a group, and then I ask them questions. So it's less competing and more trying to find a solution. And then what I also introduce is asking them to create an institution of international criminal justice. And for that, I use sometimes an article by Michelle on CIJA, Commission on Justice and Accountability, which is a private international criminal law institution. So I just invite students to get in groups and to try and design a logo, design a name, design an institution of international criminal justice, just as the way they would like to see it. So instead of thinking in terms of certainties, thinking in terms of possibilities. But the second assignment is more for graduate students who already have some knowledge of international law, international criminal law. For undergrads, like connecting to Leticia's point, I think it's for all of us, or most of us, it's a challenge to combine doctrinal approach to actually explain to them what is jurisdiction. There is ratione materia, ratione temporis, because these are still useful notions for them to understand, and also to cater to their needs, to their questions about the politics and so on. So I do teach a little bit about terrorism, and I also teach quite a lot about corporate accountability in the context of international criminal law, because I feel that it's an important element, maybe not traditionally covered so much by the tribunals, but I think it's the future. So just trying to fit in new topics, new themes. So thank you, and just pleasure to see everyone here. Hello.
Thank you so much, Marina. Okay, so time is flying. I'm going to turn to our next two speakers, and then if we have time, we can hear if our lead speakers want to say any kind of final remarks. We've only got 6 minutes, so we'll see how it goes. So I'll hand the floor now to Kirsten.
Yeah, thanks so much. It's great to see familiar faces and meet new people. As everyone was saying, very briefly, I don't teach in a law school. I teach undergraduates. And so one of the things I use ICL for is to talk about method. So I teach a lot of legal method classes. And in some ways, ICL is a nice, very unfamiliar sort of naked method or means to try and talk about, like, how does doctrine work, and then how would other contexts come in. So teaching like the sociology of law to try and make that distinction between internal and external perspectives on law. ICL, I think, provides a really nice tool. So it's a very different way around, and I think it's very distinct for the rest of people who are teaching law students. But in the non-law student, when I'm teaching sort of sociology students, ICL still provides a nice tool.
Great, thank you so much, Kirsten. And oh, someone else had their hand up, but they've now put the hand down. Was that, who had their hand up? Oh, hi, Maya, yes, please.
Hi, I had a hand out, but I mean, in the interest of time, more or less everything has been said. I just very briefly wanted to say hi to everyone, and it's a great opportunity to listen and learn from you. And maybe just my perspective of someone who has been at the other end of the international criminal justice, coming from Croatia, coming from a specific region. And what I can share from my experience is that perhaps in contrast to what you would have expected, the students here are not that interested in an ICL. And usually I have more international students coming on Erasmus than Croatian students. I've been teaching ICL for the past 10 years or so. And the challenge that I experience is, and it's an elective course, obviously, that I get students from different backgrounds, different knowledge, and you need to get them to a common ground to be able to understand. So it's very difficult to expand materials to go into transnational crimes. And we do have specific courses covering transnational crimes, transitional justice, and all of that. So my focus is on core international crimes. I do try to expand a little bit on corporate accountability, ecocide today, perhaps economic offenses. So we do try to broaden through students' presentations as much as possible. We also participated in the ICC Moot Court competition for several years, and it was a tremendously good experience in the sense that I think the students learned really a lot from it. It was a very good exercise, but I also got fed up, to be honest, with the competitive part of it, and I dropped. So it was very interesting to listen about this experimental mooting, and I also read the post on EGIL blog, so thanks for that. And I will stop here in the interest of time. Thank you.
Okay, so I think that we have Chao Yi, because I think she's trying to press the button, but she couldn't. Then after that, Chao Yi will go to Pawat, and then Anastasia. Chao Yi?
Yeah, thank you, Tia. Many thanks for inviting me. I'm a freshman in the teaching of international law. I'm from Fudan University Law School. I haven't got the opportunity to teach international criminal law yet, but I use a lot of materials from international criminal law in the undergraduate general course on international law. The biggest challenge that I encounter in teaching in a non-native English-speaking country like China, we do not have specialized legal skill or lawyering classes. That one thing I find quite difficult is that, say, for example, for Chinese students, whether undergraduate students in the sophomore year or the junior students or JM students, those students without a legal background, they have to enroll in 9 to 12 courses within one semester. So it's very difficult to build a quite comprehensive syllabus based on the doctrinal units of our knowledge from international criminal law, or even more generally, international law. but we have other relevant courses with overlapping issues, say, for example, international humanitarian law, general course on international law, and a variety we call competitions. So I feel that probably the most feasible way and also to overcome the overloaded student obligation problem is to build a syllabus based on the constitutive elements of monology units of capacity building for students. Say, for example, I usually started with sources for international law. I was a former student of Professor Jia, so I really like the material that he used for general identifying the general principles of law in etymology. So I adopted that comparative approach and also integrated some considerations around the critical thinkings of international law and some like old doctrine discussions over civilized nations where to select the problem comparable examples to study for students. And then also I am now teaching the extraterritorial jurisdiction to enforce. So I use a case of average matching as a starting point with other reactive practice from other states and ICTY's Nicology case on benefactors, detentors to inspire students to build on their knowledge after we have established a foundation of those capacities. Like as long as they know where to find the applicable sources for international law, how to identify issues through the identification of appropriate actors, probably they're prepared for moot competition to gain more knowledge. So that's, I just started teaching. So my senior colleague, Professor Zhu Dan, is not here. She is now responsible for teaching international criminal law and international humanitarian law at Fudan Law School. And also we have some more broader courses on transnational international crimes, like white collar crimes, including UN conventions on anti-corruption, so that students probably have more broader career aspirations, want to do some, for example, non-compliance, they can also have access to those. Many thanks, and I look forward to hearing more from you.
Okay, thanks so much, Chao Yi. We're going to be running. I just talked to Barry, and we're going to run maybe 5 minutes after time to let everyone have their time and also the speakers to respond. But if anyone has to leave, please feel free to do so. Yeah. So now we'll go to Pawat.
Hi, thank you. I'll try to be very brief. I admit that I have gained a lot of inspiration listening to all of you. Just a little bit of the Thai experience from my part. Well, Thailand it's not a state party, so anything happening at the ICC is very far removed from the Thai, from the Thai students in general. So the big challenge for me is how to how to give them the information or the background information of what's happening, because at one time and 1 year, I just jumped to the Rome Statute, and students were asking, like, what is the Holocaust? I'm like, what? Right? So first of all, they need to know where the Hague is and who the Hutus and Tutsis are. So my problem is to, I mean, and I welcome the experience from any one of you, how to, give them the crash course on world history. Because without these fundamental knowledge on world history, the class cannot go on smoothly. So I had to dedicate a few sessions, and I also have to give them some basic readings to read before actually starting the actual law materials, because otherwise it would not go well smoothly. So yeah, that's some, but other challenges I think I share with everyone. It's an elective course and not everyone that interested. So so thanks for having me here. Just minor intervention. Pleased to meet all of you here.
So maybe now we can go to Anastasia, and then we can go back to our speakers.
Thank you very much, and I'm very happy to be here. Thank you for sharing all your knowledge and experience. And I just wanted to give a brief 5 cents on this dilemma of international criminal law and transnational criminal law. I teach on an elective course for undergraduates, and unlike some colleagues who have mentioned the challenges of very extensive courses where ICL is perhaps a smaller part, we have a whole course dedicated to it. And one thing that I have found useful in a couple of years of teaching, so perhaps not such an extensive experience, is not to necessarily separate rigidly international criminal law from transnational criminal law, and perhaps instead in the introductory lectures of the course, talk about international law stricto, international criminal law stricto sensu, largo sensu, as varying approaches to the material scope of international criminal law, because I, in a sense, find it also useful to perhaps disrupt a little bit those narratives of rarefication of international criminal laws revolving exclusively around core crimes. And while perhaps I don't go into much depth also on transnational crimes and transnational criminality, I find it useful to perhaps give at least an introductory lecture on treaty crimes, what they are, how the suppression conventions look like, what their basic features are. And it seems to be working quite okay. Again, given that it's an introductory international criminal law course. And I just had a brief reflection on what Pawat was saying. So I originally come from Ukraine, and when I myself was a student of international criminal law, even so in the early phases of Russian invasion in 2014, what was interesting is that although Ukraine is not state party to the ICC either, we didn't really, there wasn't that kind of lack of relevance. And even, I think even before the war started, when we were law students, there was still this looking forward to international criminal law, despite, again, Ukraine not being the state party. So I think it's also, and I think the same could be said about many US law schools where international criminal law is probably taught extensively without the US being the state party. So I think that's also interesting to note how perhaps the relevance goes not as much along the lines of state party and non-state party, but along the lines of centers of power. Thank you very much.
Thank you so much, Anastasia. Maybe we could move on to our speakers to give them an opportunity to say something before we close. Or Professor Wan, would you like to start first?
You could like me to
Oh, maybe just, do you have any reflections or anything? I mean, if you don't, it's completely fine. Yes. So, because we just wanted to hear from you all before we close.
Okay, it's really nice, but I think that regarding the content of ICL we deliver to students are still different between us, right? I think that some focus on these issues, the others as well, and methods of teaching is still different. And I think that your sharings are very valuable for me. Thank you very much. And we hope that this is, as I see on the charts, this is just the first meeting, and we still have some others to discuss in details each of the issues of these. Thank you very much.
Shall I? Thanks so much,
Christine,
everyone.
please.
Yeah,
Yes.
I'll just jump in. I know that we're short on time. This has been really fascinating hearing from everyone and sharing these thoughts. And I just wanted to say two things. So first of all, on students' expectations, and I think I share what some of you have been saying, that I call it the pedagogue's projection about the idea that students must learn about doctrine, that is, and that anything that introduces theory or critique, it then suffers under some kind of selection bias. But of course, choosing to teach doctrine at the expense of critique is also suffers under a selection bias then, right? We have to make decisions about what to put into a syllabus and what to take out and what to not have in there. And I think we lean towards projection when we think about what the students really want. And that's informed by, and it's just a question of like being open with ourselves. What is that informed by? Our experiences, our own teaching experiences, and so on. What did we learn when we were students, and so on. So I think we are probably freer than we would like to admit. And then also what Marina said on possibilities. I love that you said that, Marina, because I think when you teach from a critical viewpoint, the students assume that you're somehow cynical, right? And I always say, no, there's actually something really utopian about this. And some of the possibilities that I would see and that you mentioned and that I just want to echo concern questions of corporate accountability and questions of climate justice, where then global criminality can be put into conversation with strategic litigation and using international criminal law as this forum and form of rupture. So I think there are possibilities there for future discussions, and I know that there's really interesting research going on abolition, for example. That the critique continues, and so yeah, thank you for this, for all your ideas and input.
Okay, well, I guess I'll draw this this meeting to a close with just a final remark that, you know, I guess if teaching is about choices, then, you know, in this room, we've really discussed how those choices are informed by all kinds of things, whether it be the context we speak in, the audiences we're speaking to, the resources we have or don't have at our disposal, and also our own background assumptions about the field and the world, frankly. So I just want to end by saying thank you to everyone, including our two lead speakers, but everyone in the room for sharing, and for sharing in particular your situated choices with regard to international criminal law teaching. I found it incredibly insightful and I've learned a lot. So thank you very much.
I've learned a lot, and thank you so much for your time. So we'll end this here. Have a great evening in Asia, a great day in Europe.
Take care, everyone. Thank you.